I understand there's times for mercy, there's times for compassion. But I think undeserved mercy is filtered from the cruelty to the victims. And they've been through everyone's worst nightmare. 20 plus 20 is 40, and that's really not enough, but that is the maximum allowed under law, and that's what I'm asking you to do on behalf of the Marty family, the Eisenhower family, Christopher Staggs, Foster Carr, and their entire faith community. One reason all these people, including the Gomez family, are here in this courtroom today is because of what he did, what he chose to do. And it is a tragedy up and down. And so I'm asking you to protect the citizens of Jefferson County from any chance that this can ever happen again. Mr. Gomez. Thank you, Your Honor.
Thank you.
Welcome to the Court Forever. Please like, share, and subscribe.
I have a question, Mr. Nichols, with regard to deadly weapon finding. I'm looking at the indictment, and it doesn't read that there's a deadly weapon.
Right, I don't believe it does, Your Honor.
Okay. And it's not something I looked into. Is that something I can still find if the indictment doesn't say it?
Yeah, I don't have an answer for that.
Okay. Do y'all know? If it's not here, if it's not in the indictment,
the court would have to find. It is permissible without a request, without it being included in the indictment. However, the court would have to point to specific evidence that it was used or intended to be used as a deadly.
okay.
And I would argue to the court that perhaps, if there had been other evidence, but there's really no evidence admitted upon which the court could make such a finding, so I will ask the court not to find. But I will represent the court and not to the court that it's not absolutely required to be included.
Okay. I really didn't think so. I just wanted to make sure. I would think I guess, Mr. Young, would you disagree with the information that is provided in the pre-sentence report that everyone has agreed that I review, that I could use that as far as, since I've taken judicial notice of that, the letters and everything else, that would be, would you have an objection of me using that if I were in fact to make finding of a deadly weapon?
Your Honor, I think the court, they're all evidence before the court, and there is evidence that the court point to this supports the finding of deadly weapon. I'll see.
Okay. First, I really do want to thank everybody for being here. We don't have full courtrooms like this. These, just as both of the attorneys said, these are some of the most difficult cases that any judge has to deal with for many reasons, obviously. Mr. Gomez, had you been in, well, I'm not sure that it would matter, but had you been in here and this was your first DWI, there might be some sense of what your attorney was asking for me, which is true. I mean, I have to detach myself from the emotional part, which is, it's impossible, but it's required, and I do the best I can to do that. And there are things about you and your life in the past that are good. There are things that the 3 prior DWIs should have taught you. Your age, you're 52 now, 53 now. It's the 3 DWIs previously, even though they're older, and your age, it's not the establishment's fault. Did they violate the law? Absolutely. You're a grown man. Got into a vehicle, and you know from your history, you know from your age, you know probably from telling your own children not to drink and drive, and trying to probably instill that in them, and you did it, and you did this. So at this time, in cause number 24 DCCR 1651, I'm going to find you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle, I'm going to sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. I am basing that on all of the information that's presented in both the pre-sentence report, the attached reports from the officers, in addition to the letters from Mr. Stacks, who unfortunately had to drive up and see this in person, from what they had to use to identify these two precious young lives, that there's no way that there is any doubt that you used your vehicle in a manner capable of causing death, and that you in fact did that. In cause number 24, DCCR 1652, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. Sentence you to a term of 20 years. There will also be a deadly finding in that case based on the same information and evidence that I used in the previous one. That sentence will run consecutively to cause number 24, DCCR 1651. In cause number 24, DCCR 1653, I'm also going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. Third or more, find those prior offenses true. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. That will run concurrently with the other two sentences. You will receive credit on these sentences for any time that you...
This courtroom sentencing takes a devastating turn as the judge confronts a defendant whose history of repeated drunk driving ended in tragedy. The prosecution argues that mercy, in this case, would be unfair to the victims and their families, emphasizing that multiple families and members of the community have been forced to live with the consequences of what happened. The court then addresses a critical question: whether a deadly weapon finding can be made even though it wasn't specifically listed in the indictment. After reviewing the evidence, the judge makes the decision clear. She finds the defendant guilty of 2 counts of intoxication manslaughter and determines that his vehicle was used as a deadly weapon, pointing to the reports, pre-sentence investigation, and letters presented to the court. Then comes the sentence: 20 years for each manslaughter case, to run consecutively, meaning 40 years total. The judge also sentences him to 10 years for DWI third or more, running concurrently with the other sentences. And her message is unmistakable. After 3 prior DWIs, this was no longer simply a mistake, it was a choice with devastating consequences.